All right, good afternoon, everyone, and welcome to our third installment of In the Boardroom with Attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. I'm Sarah Deidre Kasdorf, Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I will serve as your host for today. Today's webinar is on the topic of ethics. The Ethics Code for Local Government Officials seems relatively straightforward. Make sure to keep your personal interests separate from your interests as a public official. But as with many sets of regulations, the devil is in the details. So this installment of In the Boardroom will explore the basic rules of ethics governing local officials and addressing some of the more difficult concepts. Hopefully, the discussion will provide you with the information necessary to identify tricky situations and alert you to the need to seek advice from corporation counsel. So I have just a few housekeeping items before I turn it over to our speakers for today. First, with regard to Q&A, please type all of your questions in either the Q&A and the chat. We will be monitoring the Q&A and the chat throughout the next hour. However, please keep in mind that we do need to get through all of the material today. So if you notice, we stopped taking questions throughout the presentation. It's just a matter of making sure we get through the content, and we will get to your questions at the end. Second, this webinar will be recorded, and the recording will be placed on the WCA website along with the PowerPoint presentation. This will likely be done, probably by the end of the day tomorrow. Third, having done ethics training myself for county officials before, inevitably, questions will pop up asking for an opinion on an ethics issue related to something that is currently happening within your county or something related to a county supervisor or the hypothetical situation that we tend to get asked about a lot as well. Please note that the purpose of today's webinar is not to issue opinions or to answer your hypotheticals, but rather it is to provide knowledge on the code of ethics for local public officials and some criminal statutes, I believe, as well. So questions on local ethics issues should be directed to your corporation counsel, and you will learn during the webinar why that is important. So at this time, I'd like to turn the program over to our two presenters from Attolles Law, Andy Phillips and Jake Curtis. And by the way, for those of you that have joined us in the past and questioned my introductions of Andy, the answer to your question is no, he does not pay me to say nice things about him. So Andy and Jake, I'm going to turn it over to you.
Thank you, Sarah, and good afternoon, everybody. Let me start by saying that obviously Jake and I are in different locations today because we got a lot of feedback that the cozy nature of our relationship on the past presentations was interesting. So Jake and I are in separate locations today. We'll be able to talk. We may talk over each other every now and again. The reason that this topic in conversations with Sarah was selected is because, and Jake, you might have the number off the top of your head, but I would say no less than 5 or 6 in the last year times we've been brought in as outside counsel to deal with a particularly thorny or ugly ethics / conflict of interest / incompatibility question by different counties. I mean, it just seems to me anyways that some of these issues are on the rise, and I think we can all debate the why these issues are on the rise, but the fact is that it seems that there are elements out there, people that are very, very much in tune with ethical situations, very, very much in tune with the legal obligations associated with that, and that just means that we have to have a real awareness of what the ethics rules provide. I mean, I know you've been involved in a lot of these, Jake.
Yeah, no, Andy, I think that's a good way to, I think, frame today's discussion. I think it's well above 5 to 6. I can think of 4 I'm dealing with right now that you and I have talked through. Yeah, I don't know why. I mean, maybe, there's an increase in polarization and we could talk through all those little nuances. I think one thing that I have observed is that, again, whatever the reason as to why there's an uptick, I think this sort of training is really important because when you have local disputes, when you have differences of opinion, I think we're all seeing a lot of individuals turn to their ethics code to then maybe accuse opponents of ethical violations. And probably the most, I think the primary one would be conflicts of interest. And anytime that I'm talking on this, Andy, I know you and I have talking on this subject together as well. I think it's really important that people take what we're going to talk about for the next hour very seriously. Actually, we always give out these PowerPoints afterwards, read through the definitions, because it's one thing to maybe have the appearance of a conflict or something like that. But as we're going to be talking about, these are all very defined terms under Chapter 19. As we're going to talk about, Chapter 19 then provides for the option for a county to have its own local ethics code that you can personalize to your county, and there's going to be definitions there. And then if there is a finding, there can be really pretty significant consequences, in the most extreme case, criminal. And so I think it's really important that as leaders, when there always can be questions over ethics. I'm not saying they're going to go away, but I think as leaders, we need to step forward and say, look, it's one thing to maybe have a perception problem, maybe to use inappropriate rhetoric, or however you want to describe it, but to actually have an ethics violation is a really serious thing. And I think as leaders, we can step forward and remind people that there's a process to review them. As we're going to talk about today, corporation counsel plays a critical role in that. There's ethics opinions that we can look to, attorney general opinions that we can look to. So let's, as leaders, step forward, try to lower the temperature by working through the process, reviewing ethics questions in an objective way, and then hopefully, and this is what we see typically when we're involved and actually apply the legal definitions and go through the analysis, it's often, not always, sometimes we do find an ethical violation, but often it's more, let's reframe the conversation. Let's encourage members to maybe avoid certain votes, but let's try to avoid accusing everybody of having a conflict of interest or an ethical violation, because that doesn't help. So I'll get off my soapbox on that. But
no, but I mean, that's a good point, Jake. It's a good segue into the importance of this, because the reason these issues tend to be so incendiary is that ethics issues, they leave a stain. Henry David Thoreau, there's no odor so bad as that which arises from goodness tainted. It takes 20 years to build a reputation and 5 minutes to ruin that reputation, by Warren Buffett. And so as we go through these things today, understand there's a difference, to Jake's point, between perception and a violation of the state ethics code, or a local ethics code, or a conflict of interest that may be prohibited under Chapter 946, or just a simple perceived conflict of interest. We want to give you the legal background and the understanding to, again, frame the conversation that you have within your county. So let's start with this whole Chapter 19 concept, and we're going to run through this and maybe highlight a couple of the issues that we have seen over the course of the past couple of years, dealing with, again, a multitude of these ethics issues. So what entities are covered? Counties. Just understand, counties are covered, period. There are all sorts of other local government type entities that are covered under the state ethics code for local government officials, but understand that counties are covered. Who is covered? And this is important. It's not everybody that is involved with county government. It's only local public officials, elective officers of local government. That includes county boards, county constitutional officers, county administrator or administrative coordinator. In a point of office in which an employee is appointed for a specific term, that may be your highway commissioner. In a point of office filled by the head of the local government, that may be all of your department heads who are appointed by the local government. So again, it does not include, this list does not include, in terms of coverage, the word employees. All right. So employees, they may be covered by your local code. And as we'll see later, they may be covered under Chapter 946 as it relates to criminal conflict of interest. But as it relates to ethics code, the state ethics code for local government officials, employees are not covered. And so
Andy,
go ahead.
Yeah, one point on that slide. Just remember, when you have, we're often going to have committees that have a combination of 3 supervisors and then 2 members of the public. Just remember, members of the public can be subject, depending on kind of how that framework is, how that appointment is framed. They can be subject to this as well. And so I think it's a good reminder if you have a member of the public that just is, has a servant heart and they just want to help out their county and they're willing to take on this appointment, it's good to remind them that they're taking on this responsibility as well. And as we'll see in a few slides, I think that can include even a financial disclosure statement, depending on how your local code is written. And I think it's important to remind people that they're taking on that responsibility, because there may be, somebody that has a lot of financial interest that they don't want that information public. And I think it's incumbent upon us to let them know ahead of time so they know what they're signing up for.
That's right. So when we look at the categories of prohibited conduct in 19.59 is the ethics code for local government officials contained within Wisconsin statutes. There are essentially 5 categories of prohibited conduct, and we're going to walk through each one. And a lot of this seems commonsensical, and you start reading this ethics code and you say, well, that makes sense. Of course, that's right. But as lawyers, and I'm sure there are many others out there, you take a much closer look at some of the terminology that's used, and that's where it gets confusing. That's where you find ambiguity. And it's not always as easy as it seems to apply the ethics code to any particular situation. Here's what we mean. The first category of prohibited conduct. It's a ban on the use of the public position to obtain financial gain or anything of substantial value for the benefit of an individual, the individual's immediate family, or an organization with which the individual is associated. All right, again, this seems really basic and commonsensical. You can't do something that is going to produce a financial gain or produce anything of substantial value for you, your family, or some other organization with which you're associated. Very commonsensical. But what is financial gain? What is anything of substantial value? Is the pen that I am holding right now, right here, is this pen, is that something of substantial value? That pen on the street probably costs $1.50. Is that substantial value? Say that the copier supplier for your county gives away Nerf footballs every time he or she visits the county. Is that Nerf football anything of substantial value? And for that matter, did you use your public position in order to get that Nerf football? And so, as we will see through here, there are certain terms that are used throughout the ethics code that, again, seem very commonsensical, but when you really start thinking about the terminology, it's not entirely easy to define. To Jake's earlier point, we do have opinions from the State Ethics Commission that speak to the definitions of the terminology used within the statute. And so, according to the Ethics Commission, anything of substantial value, they've benchmarked it at $25 in value or more. So does that mean that you can accept something that has a price tag for $24.99? I wouldn't say that. I don't think Jake would say that. Does that mean you're absolutely in all circumstances prohibited from obtaining or receiving anything that is worth $25.01? I don't think I would say that. I don't think Jake would say that. You have to look at the circumstances giving rise to the receipt of that particular issue. And we can all think of the circumstances where it's an easy call. You're receiving a vacation to Mexico with a value of $11,000 from that copier supplier as an incentive to look favorably upon that copier supplier when that contract is up in the next couple of months. That is a problem. That's a huge problem. We all agree that that's a problem. But again, going back to the Nerf football example, is that a problem? I don't think it is. And so again, pay attention to the terminology that's used in the statute and don't just rely on a knee-jerk reaction. You'll see here in a moment, when we get to that point in the presentation, you have a get out of jail free card. That get out of jail free card is getting advice from your local ethics committee or board or your corporation counsel. I always say your first stop whenever you have a situation arise where you receive something that has any sort of value is in corporation counsel's office to say, hey, I just got this Nerf football from our copier supplier. Is it okay if I keep this and give it to my kids or grandkids? Is that all right? Corporation counsel is the individual within your county who has primary responsibility for interpretation and application of the state ethics code and the local ethics code. Corporation counsel is the expert when it comes to these things. So listen to what corporation counsel has to say. Anything else you want to say on this first category, Jake?
Yeah, 2 points. I think kind of trying to distill what you just said, I think one really important point is, I think what you were touching on earlier regarding, the pen, the football, things like that, there is a common sense element here. I think sometimes people lose sight of that, right? And they look at these terms, they are defined terms, and they kind of lose sight of the fact that I think there is kind of a common sense element here that again, I get people people get passionate in this area, and there can be local politics and things like that, but that's kind of corp counsel's job, to your point, to immediately loop them in, because they're going to be able to identify, but frankly, they're going to be familiar with the terms, and they're going to be able to look at this kind of through a common sense lens. So if you attend a conference and you get some nice swag and you come back, you're clearly there in your role as a county official, right? There's no expectation that this is going to somehow influence your vote. I mean, there's a common sense element where I know there can be specific situations, but generally speaking, that's not going to be some sort of ethical violation, as opposed to you go to a conference and you somehow get an $11,000 vacation, right? I mean, use some common sense, right? The latter one is going to be a problem. The difficult ones are, where corp counsel can, again, apply a kind of a common sense approach. You go, you get some sort of award or something. It's clearly because of your role in county government. And it's something that can be transferred to the county, right? You get a beautiful painting, right? We see this all the time. You're uncomfortable because, the value might be a couple $1,000s. What do you do with it? Well, in that situation, your corp counsel is going to help. There's probably a process whereby you can say, hey, accept it on behalf of the county, right? You don't want to reject it. It's a nice gift because of something good that happened in your county. So accept it, and we'll find a place in the administration center where we can hang it and note, this was received as an award or accomplishment for some great thing that the county did. I mean, those are the type of common sense things that a corp counsel can navigate through. I mean, I always tell the story. I was at a state agency, and the secretary would go to events, and he went to one in particular, and he got a case of syrup, right? A big case of really good organic syrup, probably valued at a couple $100s. He asked me, Jake, what the heck do I do with this? Well, we looked at chapter 19. We looked at some other advisory opinions, and you know what we did? We put it out in the lobby of the agency building, and at the end of the day, the syrup was gone. We had a nice little, free on behalf of the DNR for those that want it, and it was gone. Went to the public. It was a nice little gesture. And so my point here again is there are common sense ways to approach this. There are going to be situations where you need a 25-page memo from corp counsel. There are going to be other situations where corp counsel is going to say, put the syrup out in the lobby and let the public take it, right? And so there's common sense approach. The second point is some of it's just intuitive, but also when there are these gaps like Andy was referring to, where there's a defined term under chapter 19, it's not really clear maybe how it applies. I think what the legislature did is, remember, we're going to get to this in a second, under chapter 19, there's very clear direction that you can have your local code address your own ethics code for your specific county. As you'll see, I literally was doing this last night for a client, going through various different examples of ethics codes. And there are variations. There's a lot that's the same, right? You don't need to reinvent the wheel every time. Pretty standard language. But there's some significant nuances when a complaint comes in. If you're going to look at probable cause, do you want corp counsel to be looking at that initially, or do you want your ethics board to right away look at that? So I've noticed some important variations there where counties are going to address that in different ways. The point is, if you don't have an ethics code, or if nobody has reviewed it in years or decades, it's a really good exercise to go through to have maybe corp counsel and then somebody on the board that has an interest in this matter actually go through your ethics code. And then obviously, if you don't have one at all, you can work with us or WCA or corp counsel, whomever, to actually put one together. And again, while there's going to be a lot of similar language, there are some important differences that will relate directly to your county that you can kind of fill in those gaps where chapter 19 maybe doesn't provide all the clarity.
Yeah, I think that's a good point, Jake. And so we're spending a lot of time on this first slide simply because these definitional items carry through to other categories of prohibited conduct under 19.59. The other ambiguity it's not necessarily an ambiguity because it's not ambiguous, but it's a misconception out there, is that somebody thinks that because a board supervisor's brother did something and received a financial benefit, that that's an individual's family member, and therefore there's an ethics issue or concern with that supervisor taking a particular action. Understand that the way the statutes define immediate family, it's an individual's spouse and an individual's relative by marriage, lineal descent or adoption, who receives indirectly or directly 50% or more of their support from the supervisor, or the supervisor receives 50% or more of his or her support from that particular relative. So it's not just because you're related by blood doesn't mean that you're a member of an individual's immediate family under the statutes. The second is this whole concept of an organization with which the individual is associated. The statutes make it very clear that an organization definitionally does not include another body politic. What does that mean? That means that people who sit on a town board, a school board, a city council, a village board, whatever, there is no conflict when it comes to the county taking up a matter that is going to impact that other political subdivision. And so those organizations are not organizations under the statute that are considered organizations with which the individual is associated. And so when we look at the categories, we have the first category here, we have the second category. There's a ban on offering or giving directly or indirectly anything of value to a local public official if it could be reasonably expected to influence a public official's vote or be considered a reward for taking or refraining from taking any official action. So the important part here is that, and again, this is very commonsensical, but the thing to me that stands out here is the way the legislature drafted this statute to say ban on offering or giving directly or indirectly. All right, so that's a very broad net that is cast as a result of this particular category, because it's not just a direct offering or giving, it also captures indirect benefit that accrues to the particular county official. So keep that in mind. Anything on that slide you wanted to add, Jake?
Well, I guess there, I think the point is when you're talking about direct, indirect, and that's where this can get extremely complex, and why you need to involve corp counsel as quickly as possible, because direct obviously is a little more obvious, but what's an indirect benefit, right? I mean, that can get extremely complex and really require an objective legal analysis.
Well, and to your point earlier about attending a conference and receiving some swag at that conference, you look at this particular category and you say, wait a minute, they received that swag as a result of their status as a county board supervisor. So why do they get to hold on to that swag? Or why is it that they're okay taking that swag home? Well, again, number one, we have the anything of value, the $25 threshold, setting that aside for a moment. Is the receipt of that swag, is it reasonably anticipated that that would influence a particular supervisor's vote on any issue? No, it's there for all attendees of the conference. And so that's how, when you get into the weeds on interpretation and application of these prohibitions and categories of conduct, you're gonna find that the definitions are critically important. Third category, you can't offer a promise to give or withhold your vote or influence or taking official action on any pending matter in exchange for a campaign contribution. I mean, this is the one to me that is the most commonsensical. That's pay to play. Hey, you contribute $100 to my campaign. I'm going to make sure that your proposal to be the snowplow driver for the county parking lot goes through. That's pay to play. You cannot have that. This to me is the most commonsensical of all categories of prohibition under 19.59. Fourth category, ban on taking any official action substantially affecting a matter in which you as a board member or a county official, a member of your immediate family, or an organization with which you're affiliated has a substantial financial interest. Again, understand the definitions. We know who an individual is, that's fine. But who is in your immediate family and who is or what is an organization with which you're associated? Now, again, I want to distinguish, and we want to make sure we distinguish between a real ethics issue and a perceived ethics issue. Getting back to what Warren Buffett said on the second slide of this presentation, that it only takes 5 minutes to ruin a reputation. Just because it's not a violation of the ethics code does not mean you're not going to get vilified in the press over it. So that situation where your brother has a contract before the county board and you're going to debate on the merits of that contract and actually vote on that contract with everybody in the county understanding that it's your brother's contract, how useful is it to you to stand up a day later and say, yeah, this newspaper article vilifying me is wrong because it's not a violation of the ethics code because my brother doesn't receive 50% or more of his support from me? That's a small, small consolation prize for ruining your reputation. So understand that even though there's a distinction between real and perceived conflict of interest or ethics issue, doesn't mean that you shouldn't exercise sound judgment and perhaps recusing yourself from certain situations to avoid even the appearance of conflict. Thoughts on that, Jake?
I think here the biggest point is really for the last few slides here. I mean, if you look at that to your point about, well, it may seem common sense. Some of these are common sense, right? And I would agree, you know, the Chapter 11 political contributions, right? That's pretty straightforward. This one, I would just encourage everybody to read that sentence. Almost, right? I mean, not everyone, but for the most part, each one of those key terms is defined. And to your point, right? So we can focus on, well, is this brother, you know, to use your hypothetical, is this brother an actual, does he fit the definition of a family member, right? I mean, there could be a technical analysis there. Official action, right? You're going to have situations where the board may be weighing in on something. You know, it could be a resolution. It could just be something that's, you know, brought up in public comment that then results in a debate at the next board meeting. Is it something that what I'm getting at is it something that the county actually will ultimately control? And to Andy's point, you can have situations where maybe, you know, if we're viewing this from a technical standpoint, maybe there's not going to be official action from the county. Therefore, it's not a violation. But if it's something, you know, if it's a big debate, a big development that multiple units of government are at least going to be remotely involved in, is it really makes sense? And you have some sort of personal financial stake in that development. Do you really think it's good for you to be involved in those board conversations, even if it doesn't necessarily meet the official action here? And so again, my point is almost every word there in this sentence has a definition associated with it. And we can go through from a technical standpoint and maybe find, ultimately conclude that there's not a violation, but then there's the perception problem. And this is where it gets super complex. And to Andy's point, you need to think through, even if it's not technically a violation, do you have a perception issue to the point where you are impacting the operations of county government or the ability of a board to navigate an issue?
Well, and I think it's important to point out the interpretive exceptions here. And these are well accepted by the Attorney General's office, by the Ethics Commission, by everybody, all right? Is that I often hear, hey, I'm the county board supervisor. We have on the agenda the approval of a 3% across the board wage increase for all employees in the county. My wife is a county employee, so therefore I am going to refrain from taking action on that. Well, okay, you may want to do that for perception purposes, but the law makes clear that you're not required to do that. Why? Because your wife happens to be a member of a large class of people who are benefiting from that 3% across the board wage increase. Where we have issues with that, and where I have an issue with that, is where we have supervisors that think, real or perceived, they can't take action on that particular item, and that item is as part of a much larger package of items, namely the county budget. All right. So you have an entire county budget that is before the board, and one provision within that budget says we're going to give 3% to the employees, and you have a supervisor abstaining. Well, how is that supervisor representing adequately the constituents that put him or her in that seat if they're going to recuse themselves from deliberation and vote on the budget? They aren't. And so again, understand that this interpretive exception applies. That interpretive exception also applies to taking official action on an ordinance or resolution that comes before the board. But again, let me just remind you, because this is important. Just because the law allows you to do something doesn't mean in every circumstance that you should do something. Big difference between the words may and should. So keep that in mind as we proceed through this discussion.
Yeah, and I would just add there, so I think you see it a lot with personnel wage increases. We also see a lot of questions relating to land use issues and when you have supervisors or other county officials who own land in a county that are going to be impacted. That's where that class analysis gets, is very important. And I guess, so the example would be, you have some sort of adjustment to zoning that's going to impact the entire county, and supervisors obviously live in the county, they may own other properties. That's one where probably a class analysis can result in, the class is the entire population in the county that owns land, versus, you'll see situations where there's action taken at the county level that's going to impact a specific piece of property, and you have a supervisor that owns an adjacent piece of property. And there it gets really, and again, we keep talking about right, there's a common sense side and there's a technical side. Here, there's a technical analysis of, well, how big is the class, right? If that development that the county's involved in is going to impact 1,000 property owners, yeah, the fact that a county supervisor owns lands adjacent to that development probably isn't going to result in a finding that he or she needs to abstain, versus there's only 4 properties, right? There's only 4 properties that are adjacent to this development. Now you have a class problem. And so again, we don't want to get totally into the weeds, but the point is these get complex and you just need to work through that analysis.
Joe just put in the chat a great point. And Joe's a corporation counsel. I know Joe. I've talked with Joe about ethics issues in the past. He said, why would you even want to be in the same zip code as an ethics issue? You wouldn't, you don't, which is, again, it highlights the importance of talking with corporation counsel about these issues. At the very least, even if it's not an ethics issue, if it's a perceived ethics issue, you can stand up and say, I went through this in detail with corporation counsel, and corporation counsel concluded there is no ethics issue here. That is worth its weight in gold. So use it. 5th category and final category of prohibited conduct under 1959. It's a ban on the use of your position in a way that produces or assists in the production. Again, we're talking about casting a wide net with this language. Produces or assists in producing a substantial benefit, direct or indirect, for you, your immediate family, or an organization with which you're associated. So again, you can't use your office or position to produce a substantial benefit. Seems commonsensical, but again, look at the terminology used within that statute, and you'll see that when you drill down, it's awfully difficult to pinpoint exactly what is going to lead to a potential violation of this particular category of conduct. As I stated before, there's nothing in the statute that prohibits you from taking action on salaries, benefits, or reimbursements. And when we talk about the violation, Jake mentioned this before, the consequences are severe. And we have monetary consequences, we have fee shifting statutes, we have potential forfeitures. To me, all of that is minuscule compared to the cost that it takes on your reputation. There is a huge problem with whatever happens with your reputation as a result of an ethics charge. The other issue I will tell you that is hugely problematic, and this is more of a concern for everybody other than the person with the ethics issue, is that it calls into question the vote that was taken at a particular meeting. It calls into question the action of the county in approving or not approving a particular measure. And when the public loses faith in how the county board especially is operating at a policy level, you got some significant issues. And nothing causes the public to lose faith more than a board that is tainted with ethics concerns. So avoid it. Each of you as county board members have a responsibility to the county and to your fellow board members to maintain a squeaky clean reputation. That's critical. That's important. So let's try to do that as much as we can. As I mentioned before, we got to get out of jail free card. Use it. I mean, that's like the gold standard in Monopoly. You get that get out of jail free card, you're going to hold on to that until the most opportune moment of the game to use it. So same situation here. is that if we have the ability to get an advisory opinion from corporation counsel or our local ethics committee or board, let's get it. Important concepts here, two important concepts. Number one, get that opinion in writing if it's a serious issue. Two, make sure that you get the opinion before the action in question comes up. There's no such thing as an advisory opinion after the fact. It's an advisory opinion to provide advice before something happens, and then follow the advice. You lose all the protection to get out of jail free card if you don't get it before the action in question occurs and you don't follow the advice. All right, so use that get out of jail card a lot. Have that discussion with corporation counsel often. They're the experts. They know how to interpret and apply state statute and local ethics codes. Jake's mentioned earlier, counties have the ability to have their own local ethics code. And the same problems that we see with the state ethics code about vague terms, ambiguous terms, and the lack of precise definition, those problems persist with local ethics codes as well. And so the statutes define what you can do in a local ethics code. We don't need to go through all of the elements of things that can be contained within a county ethics code, but I want to talk about a couple of really important concepts from my standpoint, and then I'm going to let Jake interject too, given his work in this area. The first is this concept of a probable cause determination. Jake mentioned this earlier, is that we have seen ethics claims of ethics violations, ethics code violations, come through as political weapons. When somebody is upset about the way somebody else is acting with respect to a matter, they're going to claim an ethics issue and try to get an investigation launched against a particular supervisor or other county official. That's using the ethics code as a weapon. We don't like to see that. Oftentimes, when being used as a weapon, the particular charges have zero merit because they don't amount to, even if everything that is in that charge is true, they don't add up to a violation of either the state ethics code or a local ethics code. So there ought to be some sort of screening process on the front end to make sure that there is jurisdiction, there is an alleged violation of the law, whether it be local law or state law, that we have all the facts necessary to make a determination. And that initial screening process ought to be done, at least in our opinion, by a person that is not the ethics committee or ethics board, which may have to ultimately resolve the particular charge or complaint. And so typically we see it going through corporation counsel's office. Again, corporation counsel are the experts who understand how to interpret and apply the ethics code. So they make the initial determination. Does what's being said here add up to a valid ethics charge? I will tell you that corporation counsel oftentimes is in a very difficult spot because they don't want to be accused of playing favorites among members of the county board as it relates to that screening process. And so the local ethics code may contain a provision that allows corporation counsel to bring in an outside person, typically outside counsel, to review the situation to determine if probable cause exists. The ethics code may provide that that initial determination is put in writing to be provided to the complainant in that circumstance. All of those things are really good ideas, things you don't have to do. But when we think about administration of a local ethics code, at least in my mind, it's critically important that we have that process in place. And I will tell you the second important thing besides that initial screening process is to make sure that we have an understanding of a process that we utilize for adjudication of these ethics issues. Understand, because a lot of this, just like an ethics issue, is based upon reputation. Whenever we're dealing with a process like this, we want to make sure that we appear that we are not playing favorites. We want to make sure that everybody is getting a fair hearing on this, the complainant and the official that's being accused of an ethics problem. So let's make sure that we follow the appropriate process and we understand that process. Jake, what else have you seen from the local standpoint?
Yeah, a couple points. I guess first, going back to the previous slide, I mean, Andy is absolutely right that this has to be an advisory opinion as opposed to a review of conduct that's already occurred. I think a practical point there is, I'm assuming there's lots of corp counsels on the call or on the whatever we're calling this video. Have that conversation with your new board right? I think sometimes those of us who have been involved in county government for a number of years forget, and I guess I always remind myself because I was that 28-year-old new member on a county board. I hadn't had the opportunity to work with Andy yet. I came on, had no clue what public records were, open meetings, ethics. I had no idea, and I was already had my law degree at that point, but it's not always intuitive. And so there's a practical point to corp counsel. In addition to all the things you already have to do, maybe have that that reminder or that quick briefing with your new board in April, explaining what it means to get an advisory opinion. Because I mean, Andy emphasized it. It is so critical to avoid significant problems down the line, that when there's some contemplated action, if a supervisor is aware of the potential conflict or a potential ethical concern, that they raise that with corp counsel, so that then you can do your job. It's a lot easier to put together an advisory opinion than trying to untangle potential ethical or conflict situations after the fact. And that's a lot of what we do. I can tell you, having drafted many of them with Andy, advisory opinions are far easier to handle. And then I think the other point I want to make on this slide is Andy's absolutely right. And I'll call it what it is. It's the weaponization of ethics codes. You see that a lot. And it's important, therefore, to have a check. And as Andy alluded to, I'm not going to say it's necessarily wrong, but I think it is important to have that objective check to make that probable cause determination before it gets to your ethics board. And typically that is going to be corporation counsel, because they can be objective. And then if your ethics code is drafted correctly, there is going to be that out for your corporation counsel if they're entangled, or if you're a rural county where really anything that gets out is going to be county news. There may be situations where corp counsel is not in a good position, so you need to be able to rely on outside counsel. But I think that check is really critical. Again, I'm not going to say it's wrong if it goes directly to the ethics board, but to Andy's point, if they're making that probable cause determination, I mean, yes, it's theoretically possible that they say there's probable cause, but that ultimately, after looking at the facts, that this is actually not a violation. That's possible. I just think it's really putting your board in a really tough spot. And, particularly, presumably you're gonna have some people who don't have a legal background, and it's a very technical finding. So I think it's better just to have that outside observer, whether it's corp counsel or somebody else, make that initial determination to make sure that there's actually something there, and that the code isn't being weaponized against a political opponent. So I could go on, but I think those are the two key points there.
Yeah, and because we're through the slides dealing with state ethics code and local ethics code, which are obviously the two important points that we wanted to make today. That's why we started with those. But I want to address a couple of things that came up. The question came up, did I see a slide that said that I get to vote on any ordinance, that's not a violation of the ethics code? Yeah, that's what the ethics code says. But I will tell you that if you vote on an ordinance that has a significant impact on something with which you're involved, I don't care if it's a violation or not, you got an ethics issue by perception. And so avoid it. All right. And then the question came up. So do I have to refrain from voting? Do I have to refrain from debate? Do I have to refrain from both? Talk to corporation counsel in any situation that arises. But to me, if you have a significant interest in a particular issue, it makes no sense to vigorously debate the issue and then abstain from voting because of that ethics or conflict of interest problem. You should recuse yourself from all debate and from all voting, and you want to make sure that the clerk notes in the minutes that you have recused yourself from this. All right. That way, if the issue ever comes up later, you have written proof that you absented yourself. You refrained from taking any official action, whether it be through debate, through vote, or otherwise. So I would do that. Let's talk about here, as we move through the state ethics code and the local ethics code, this smell test. This presentation is going to be available to you after, as Sarah said, we are done here, tomorrow probably. Print out these slides on the smell test, keep them either on you or on your desk, because if any of these questions are answered yes, go talk to corporation counsel, all right? Again, the smell test is not the law. You're not going to find it in statute. You're not going to find it in ordinance, but this smell test I found to be a pretty good indication of a problem that may arise. All right, so want to deal briefly with this whole issue of compatibility. Jake, why don't you talk about incompatibility? Because we've had this issue come up. And incompatibility is a doctrine that you're not going to find in statute, but it's a common law doctrine that exists that says you can't hold conflicting positions at the same time because of a supervisory interest in one position over another. Is it an ethical issue? Not necessarily. It could be, but it's more or less a common law doctrine that exists in the public sphere, if you will, that speaks to this whole concept of not holding simultaneous positions that are in conflict with one another.
Yeah, I don't know why we've seen an uptick in this. I actually don't really even have a theory on that, other than maybe it's just luck. But we have definitely seen an increase in these sorts of questions. And I think Andy, you summarized it well. And this is another one where there's going to be really obvious, right? If you're a county supervisor, you can't also serve as a department head, right? I mean, there's gonna be some obvious ones, but there's some nuances, right? If you're, you see it in law enforcement a lot, right? Cops, deputy sheriffs, they also wanna then serve on their county board or their city council, right? I mean, so these get very fact specific. I guess I'll just leave it at that. We could go through any number of scenarios. So I think it's more to understand kind of conceptually, right? And this is why we actually went to even McQuillan, right? And just really basic foundational principles. I think the one that I wanted to highlight is that it's not so much that you can navigate this, right? Because sometimes if I have this position, is there a way I can kind of navigate serving on this board? I just won't vote on certain issues. That kind of is missing the point. The point is that you just inherently have two positions that are incompatible. And this is why we highlight this definition, the mere acceptance. So, right, you're in one position, the mere acceptance of a second incompatible office per se terminates the first office as effectively as a resignation. What does that mean? Essentially, you're in one position, you accept a second position, you have essentially terminated your role in that first position automatically, right? Now, even if you're still on the board, from a legal standpoint, you've automatically terminated your position on that board. Why? Because they're incompatible. And that leads to, I think, the second kind of conceptual point, and that is this concept of superiority, right? That one position or office is simply superior to another, such that any sort of budget discussion is going to impact the other, right? And so now, at that point, you should start seeing kind of the similarities between what we're talking about from a conflict of interest standpoint and an incompatibility standpoint. There are similarities, right? But the more important point here is there's really significant implications. If you don't identify that, the concern is that if you've continued in those dual roles, you can impact actions that have been taken while you've been in both of those roles. And so that's why it's really important to understand this conceptually so that your corp counsel can go through that analysis and identify if in fact you have an incompatibility problem. And so certainly similar to the advisory opinion, you want to identify these beforehand. So again, if you're corp counsel, it makes sense to have this conversation early on with your board so that if you have somebody that has an incompatibility problem, there may be an uncomfortable conversation where they have to resign their position as a board member, or if they have some part-time job that would be inconsistent with their role as a supervisor, they may have to quit that job. It's going to be a heck of a lot easier to have that conversation immediately versus, let's say it's identified 12 months down the road. As corp counsel now, you're going to have to look back at the actions that have been taken in the last 12 months to make sure that they haven't had an incompatibility problem. And if you do, are there any actions that have to be unwound? So this gets very complicated, very complex. And so that's why I'm really focusing on the concepts. If you have two positions, are they incompatible? Is one superior to the other? If you have any doubt, you need to work with the corp counsel. If you are corp counsel, work through that analysis and identify them, because there are ways to remedy it, right? Unfortunately, I would say maybe a third concept here, abstaining from votes, as the Attorney General has advised, is not a remedy. One of the positions has to go. And so that's why this becomes really significant, because you're talking about potentially quitting a job or removing yourself from a board.
So talking about the next set of unique issues we've encountered, as everybody knows that just like the old saying, what happens in closed session stays in closed session. Everybody says, well, what's the legal remedy if it doesn't stay in closed session? Well, there really is no built-in remedy in the statutes to say whatever is divulged outside of closed session is subjects the person who divulged that information to some sort of penalty. There's nothing in statute that says that. Well, this raises all sorts of concerns, especially from our standpoint, from corporation counsel standpoint, about privilege conversations. When we communicate with our clients, that conversation is privileged. And if a client repeats what was said in that conversation to a third party that was not involved in that conversation, is not under the cloak of privilege, it potentially waives the privilege to all conversations between us and our client. That's not good. That's a bad situation for us and for the county. And so we have to make sure that we follow certain rules related to maintaining privilege and maintaining confidentiality of closed session discussions. So can you, in your local code, have a provision that speaks to implications for violating the confidentiality provisions of a closed session? Yes, you can. All right, that's allowable. So is this something that you ought to consider incorporating within your local code? As far as I'm concerned, as far as Jay's concerned, yes, address that in your local code. Again, talking about all of the ethical responsibilities associated with closed session and so on. All right, before we move on and briefly review the F word here, Jake, anything else you wanted to add about those topics?
I mean, I think the last one, again, I don't know necessarily why, but we've seen an uptick in questions relating to the importance of keeping confidential information that you receive in closed session confidential. And I like the way how you framed it, Andy, because, yeah, typically the question is, what sort of violation under state statute is releasing that sort of confidential or otherwise privileged information. I always tell people, don't look to state statute, look to the ethics code. What's happening there is you have an ethical violation, and try to remove yourself a little bit from the situation and not be so concerned about the specific information. Just generally, as corp counsel or as anybody really concerned with ethics, view it as a county supervisor, you're going to be in the possession of all sorts of information. You are going to be in the possession of privileged information that you receive from your corp counsel or from outside counsel. Yeah, but you're going to be in a position where you have access to personally identifying information, right? Social security codes, emails. You're going to be part of negotiations over a development, and you're going to be collective bargaining with your public safety, right? I mean, there's any number of issues. As a county supervisor, you're going to have access to really, really critical information. And just like if you were at a corporation, right, the expectation is that you don't disclose that information outside of proper channels. And so it's no different when you're in a closed session, right? I mean, this isn't open meetings training. We've done them before, right? There's the 11 very specific exemptions that allow you to go into closed session. And your corp counsel will have gone through and specifically identified why you have the authority to go into closed session. And if you're going to put in all that work, and you're properly in closed session, then you as a supervisor have I would argue, again, it's not so much statutory, it's an ethical responsibility to protect and preserve that information. And if you turn around and publicly disclose that, there should be something that can be done. And if you can't look to state statute, that's where Andy's point I think is important. Have a good definition. What does privileged or protected information, what does that actually mean? Connect it to the information that you received in closed session, and then have some sort of remedy, whether it's a censure or something like that. But that's where you kind of, as a county, have a responsibility to deal with that issue. You can't, Chapter 19 is not going to be a fallback on that. You have to spell that out in your local code.
Well, and I would say too, is that just to wrap up the discussion on local code, state ethics code incompatibility, is that it places, especially in the less populated and rural areas of the state, it places local government officials, county, especially town, city, and village, places you all in a very difficult position. Because oftentimes people, I understand and I know what everybody is making in terms of money. Nobody is doing this for the money. All right. I know people are doing this with a heart of service. They want to provide for their local community. And so situations arise that say, hey, we need some people to fill in over here with EMS. So I'm going to volunteer as an EMS provider. I'll get certified and do that. I'm also going to be on the county board. I'm also going to be on this board. Well, all of a sudden, if the county board is starting to appropriate money to EMS, EMS is interacting with county board, you got town board that's interacting with you. All of a sudden, you got these situations that arise, whether it be incompatibility, conflict of interest, or ethics, that cause problems. And yes, I know that having that be vacant is an even worse problem, but the concern that I have, that Jake has, that other lawyers have, is how do we unwind everything that has been done under this problem associated with incompatibility or ethics or conflict of interest, meaning that are all of the votes that were taken to authorize certain measures and so on, are those all in question now? And that is a huge problem that we've got, trying to unwind all of those issues. And so oftentimes you will find that there are ways to navigate these challenges, ways to navigate the issues and get through them without creating an ethics or conflict of interest situation. So have the conversation with corporation counsel up front and say, is there a way to navigate this? Because doing things after the fact always is going to cause problems.
Andy, there's a good question here, and I think I'll just quickly address it. I can't tell who the author is, but basically the question is, you know, there's a lot of difficulty filling local, town, village, city boards, maybe school district, and then also serving on the county board. That's kind of an issue for me, because I see that often as something to be weaponized, right? That you have a county board issue, and then you have somebody who's also very active and serves on their town board, city council, village board, whatever, and that's kind of used against them. I mean, it's possible that there are conflict issues, but for the most part, simply because one serves on their town board and the county board, that's not a conflict. And frankly, as I think the commenter is noting, that happens across the state, particularly in rural areas, to Andy's point that you just made, right? There's going to be areas where, let's face it, it's human nature. You're going to have a small set of people that really do a lot of the work and are very service oriented. So they may serve on their town board, and they're also going to serve on their county board. I've also often taken the position that there could be a scenario, I'm not going to say it could never happen, but just inherently, that is not a conflict, right? I mean, somebody can absolutely serve on their town board and do everything they can for their constituents there, and then also serve on the county board. And now there may be an ethical obligation on the part of that individual to make sure that when they're on their town board, they're thinking in terms of what's best for their town. And then when you're on the county board, you do represent your district, but you really represent the whole county, right? And so what's in the interest in the county? So you could have a situation where something is better for the entire county that may have an impact on your town. And so at that point, you have an ethical kind of personal obligation to navigate that, right? And that's just, if you're deciding to serve on both of those boards, that's incumbent upon you. But to automatically say that's an ethical violation, and therefore that person who serves on their town board has to recuse themselves on everything that impacts their town, because I've seen that argument made, and I do not agree with that.
All right, I'm going to work through just these last slides again. Take a look at the presentation, because there are situations that I like to say lead to ethics plus problems. What do I mean by that? Is that there are certain ethics issues that amount to a conflict of interest that is prohibited under 946.13. All right. 946.12 deals with misconduct in public office, different statute. These are prohibited conflicts of interest that will be a felony if you engage in them. All right. The elements of this are particularly important. And the thing that I want to highlight, because again, you can read the slides, is that when we talk about conflicts of interest, there are certain exceptions and so on, that there are certain situations where abstaining from voting or debate will not be enough, all right? If you look at 946.13(1)(a), that conflict of interest situation arises by virtue of the office that you hold and by virtue of the financial interest that you have in a particular matter that comes before the board. So you don't have to take official action or refrain from official action in order to be liable under this statute. The fact of you holding that office may lead to a violation of this statute. What's an example of that? Well, if the county board by law has supervisory authority over a particular issue, the county board is required by law to act on something, and that something it's going to act on produces a pecuniary interest on your part, pecuniary meaning financial, then that is a prohibited conflict of interest. It cannot happen. All right. So again, be aware that there are certain ethics plus situations that could lead to felonies in certain circumstances, and you should do everything in your power to avoid those circumstances, obviously. Anything you want to add on that, Jake, before we try to wrap up?
No, I mean, I think the take-home point on that is this is where we will often see this in contract situations, right? So a contract is put in front of a board or committee, and the individual, or the most obvious one is the individual has a stake in some company that's potentially being contracting with the county or a family member, right? I mean, so just I would personally from there look at contracts, right? I mean, be mindful of any sort of contract that the county is entering into, and if a supervisor has any sort of stake or role in that outside company or entity that's contracting with the county, you have to be very careful. I think Andy, I think you would agree, like that's typically where we see this, and again, where make sure that advice is happening beforehand so that corp counsel can provide that good advice, because if a contract is entered into and there's a violation found after the fact, to your point, Andy, there's going to be potential criminal issues, but then also from the county standpoint, you may have to unwind that contract. So just review them prior to and provide good advice.
Last thing is that I want to provide you with a real world example so that you are equipped to handle this real world example when it happens. So let's imagine that there is an attorney that does a lot of work with Wisconsin counties, assists county officials to ensure they comply with the law. They're attending a conference where you're also an attendee. The attorney picks up the tab at the bar. It's a minor expense for some, but it's a big expense for others. Attorney picks up the tab. Do you violate the ethics code by not at least offering to reimburse the attorney for that sum? Jake, what do you think?
Probably a cheap beer, so we're okay. De minimis.
Are you serious? I was hoping that you would say that it would be an ethics violation for you to not offer to buy that lawyer a drink, purely hypothetically speaking here.
Hypothetically.
That's not an ethics issue for doing those sorts of things. So, all right, we got through the presentation. We spent a little time on conflicts of interest, the dreaded F word. If you have questions about conflict of interest under 946.13, reach out to me, reach out to Jake, reach out to WCA. We can certainly elaborate on that further. Let me just make sure that we do not have any pending questions and answers we didn't answer. We don't. Sarah, do you want to wrap us up here since we're a little bit past the hour?
Yep, I will do that. First, I want to start by thanking Andy and Jake. As always, extremely informative. I learned some new things listening to the webinar today as well. So thank you for sharing all of that knowledge with us. Again, please feel free to reach out to WCA, Attolles Law, if you have any additional questions. I do want to thank you as well for joining us this afternoon. This will be posted on the website, likely because I am not in the office today, and it will be posted sometime tomorrow. But I also want to remind you that In the Boardroom does happen every fourth Wednesday of the month, and our next two In the Boardroom series and meetings in May, our topic will be public records, and in June we will discuss the issue of dams. So again, thank you so much for joining us, and we hope to see you next month.
Thank you all. Have a great day.